thumbs up, which means we're live. Welcome, everybody. Those of you who are in the room here at the Central Hall in Westminster, very good to see you. And those many of you who are joining us online. I'm sure we all would much rather be together, but we're still in these rather difficult circumstances. I think most people will be aware the Prime Minister's going to hold a press conference not very far from here in a very short space of time, when it's likely that there'll be some increase in our need to be careful. So I hope everyone in this room will adhere to the need to be socially distant and wear masks if they feel comfortable, or indeed anyway this evening. But let not that dampen our enthusiasm. This is the annual Family Justice Council debate, and it's very good to have a proper debate, and I'm looking forward to it this year. The Family Justice Council, you'll all know, is a multidisciplinary body which looks at all aspects of family justice and is the meeting place where ideas come together and where those who are on the council have time to consider important issues rather than simply, as the rest of us do in the other committees that we may or may not be part of, deal with pressing issues from time to time on a more practical basis. And the council have considered what motion to have and chose tonight the motion, should the age of majority be reduced to 16. It's a topic that comes up every now and again, and to my mind it couldn't be more topical now, the more one gets to understand just the engagement of young people with life and the good sense that frankly comes out of the mouths of many young people. But I shouldn't express a view on the motion because it's too early in the day, and heaven's sake, I'm meant to be impartial because I'm the chairman. The arrangements are that Amplitude, an organisation, are providing the media connection for all of you to join. I think you've all got your cameras and microphones turned off, but we're looking forward to a lively question and answer session after the 4 sets of speakers have each spoken. So if you've got questions or observations or a mini speech, pop them in the chat bar. That's being monitored by the team at the back, and when we get to the time for the questions and answers, Jenny Beck, Queen's Counsel, is going to be firing the questions. Jenny is extremely able and feisty advocate, so even if your question looks rubbish on paper, it'll sound good when Jenny transmits it into the room. And we hope to have a discussion of about an hour or so at the end of the debate. Each speaker is going to speak for 15 minutes, and I'm going to hold them pretty much to that because I think that's fair, and it's also humane to all the rest of us to get on with the evening and see the debate as a whole. First up is Ruth Henke, Queen's Counsel. We're blessed with 2 very well known and very highly respected silks to lead the motion on each side. Ruth practices from 30 Park Place in Cardiff and has a strong, high-level child law practice across the whole spectrum of child law. She's well placed to speak for the motion, and so I hand the microphone over to you, Ruth, and set the clock ticking now. Thank you.
Well, Mr. Chair, it's my pleasure to propose this motion today. And we say that the age of majority should be reduced to 16. And we say that for 3 reasons. Firstly, 16 reflects the age when in a modern society most have sufficient understanding and experience to make informed choices and to take responsibility for those choices. Secondly, reducing the age of majority to 16 will provide greater uniformity and consistencies of law. Thirdly, reducing the age of majority does not prevent the provision of safeguards and protections from those who need those safeguards and protections. Mr. Chair, there is no one day in real life when a person wakes up and suddenly gains sufficient capacity to make decisions for themselves. In real life, it is a continuum dependent on a number of variables that include context, intellectual ability, and life experience. The age of majority in law, as you will know, is actually a legal fiction. It describes the age at which a person acquires the capacity to exercise all the rights of an individual who is not under a disability. Section 1 of the Family Law Reform Act 69 currently sets that date. That Act came into force on the 1st of January 1970. It reduced the age of majority from 21 to 18. At the same time, it reduced the age of free marriage to 18 and reduced the age that a person had to be before they could make a will to 18 as well. It did not reduce the age of franchise. That was reduced by Section 1 of the Representation of the People Act 1969. Both of the 1969 Acts reduced the age of majority and franchise on the recommendation of the Leahy Committee in 1965. By a majority of 9 to 2, the committee recommended the reduction to reflect modern society. A paternalistic society which protected people until they were 21 was then said to be out of step with the sexual revolution which brought greater autonomy at a younger age, and that needed to be recognised. Mr. Chair, in the past, children had been regarded as the property of their parents and were subject to the rights of their parents over them. But the law, thankfully, has evolved. In 1986, in Gillick, Lord Scarman said that the principle of law is that parental rights are derived from parental duty and exist only so long as they are needed for the protection of the person and the protection of the child. When the Children Act came into force in 1991, it recognised that parental rights are derived from parental duty. Accordingly, it was drafted in terms of a parent's responsibility to a child, not his right over that child. The UNCRC is now incorporated into primary statute in Wales and is taken into account when policy is formulated in the Welsh Parliament, known as the Senedd. In March this year, the Scottish Parliament voted to incorporate the UNCRC into Scottish law. That is a move to right-based law. We accept that the Children Act 1989 and the UNCRC still define a child as a person under 18. But that definition, like the age of majority, is just a legal fiction. It's 50 years since the Leahy Committee reported, 30 years since the Children Act came into force. We now live in a society that recognises children have rights and that encourages their independence. Young people now have access through the internet to the world. That access exposes them to life and to experiences which 50 years ago a teenager would not have had. Some of those experiences are good, others bad, but all inform and shape their maturity and their ability to make informed choices. In Wales and in Scotland, the maturity and capacity of young people to make informed choices has already been recognised by giving 16-year-olds the right to vote in their local and their national elections. It is recognised in Wales and in Scotland already that giving a 16-year-old the vote places significant responsibility on their shoulders. But that is not a reason to take away their ability to make informed choices. Rather, it is seen as placing a responsibility on society as a whole to ensure that young people have the knowledge and the ability to make those choices. Informing and empowering young people is not a backward step. It is a benefit to society as a whole. Political decisions are about the future. 16-year-olds have a future to look to. They know what their future they want looks like. By engaging people at 16 rather than 18, as a society, we raise a politically informed and engaged community better able to make decisions that impact on all our futures. Increasing responsibility actually increases and improves maturity and social responsibility. There can be no greater responsibility than exercising your vote and shaping your country's future. If you're mature enough to do that, then we say you're old enough to have legal capacity and to be recognised as having that capacity. That brings us to the second limb of our argument, greater uniformity of laws. As matters stand, there is a significant variation in ages at which a person can take on significant responsibility. Many responsibilities already fall on those under 16. A competent child before their death can consent to their organs and tissues being used after their death, regardless of their age. It's a matter of their capacity. A child can bear criminal responsibility from the age of 10. They can have a bank account at 11, but not a loan. They can work part-time at 13 and full-time at 16. Provided they earn sufficient sums, they're liable to national insurance contributions. A person aged 16 can consent or refuse surgical, medical, or dental treatment. They can consent to sex. At 16, you can drive a low-powered motorcycle. You can drink wine, cider, and beer with a meal in a restaurant, but you have to wait to 18 to be able to buy it. A child is defined as a person under the age of 18 in the Children Act, but Section 9(7) already states that no court should make a Section 8 order other than one varying or discharging an existing order in respect of a child who has reached 16 unless they are satisfied that the circumstances of the case are exceptional. A person under 16 has the capacity to enter a contract, but those contracts cannot be enforced against them unless they have bought a necessity. A person has to be 18 to secure a mortgage or finance the car. They have to be 18 to buy land or enter a lease, but those under 18 can have a licence. You have to be 18, as we've already said, to make a valid will. Pause there, and we invite you to think of some of the anomalies. A dying child can consent to organ donation if they are sufficiently competent to do so. They can consent or refuse medical treatment, and once 16, that decision can only be overridden by best interest decisions in the court. But they cannot decide who to give their belongings to on their death. They can have sex, work, pay tax, and save money in a bank account, but as the law stands, they cannot buy or rent a home to live in. That leaves us to a third string of our argument. It is not necessary to maintain the age of majority at 18 to protect young people. We argue that protecting young people should be about empowering and enabling them to stand up for themselves. When the Family Law Reform Act 1969 came into being, it reduced the age of free marriage from 21 to 18, but continued to permit marriage at 16 with parental consent. At that time, parental consent was seen as a safeguard against abusive marriages. 50 plus years on, the Marriage and Civil Partnership Minimum Age Bill has just had its second reading. It aims to raise the minimum age of marriage to 18. By doing so, it sends a loud message that child marriage is unacceptable, full stop, and that children should not be forced into marriage. It criminalises the behaviours of those who do cause a child to enter a marriage. Mr. Chair, we say loud and clear that no child should be forced into marriage. Those that enter into a contract of marriage must have the capacity to do so without the undue influence of their parents and families who seek to contract a marriage for their own gain. However, we say the route to protection is to empower the 16-year-old to make the informed decisions, and when they do, society should back their decisions. We say no should mean no, but don't punish the 16-year-old who genuinely wants to get married. They can have sex, they can live together, they should be able to marry. Punish the adult who uses their ability to consent to marriage abusively. Marriage, like voting, brings with it responsibilities to yourself and to society as a whole. The key to enabling informed decisions about marriage, we say, is just like voting. It's education and information to enable those at 16 or 17 who wish to make choices for themselves and take action to ensure their choices are respected. Approaching matters in that way respects the young person's right and their autonomy. Some will make bad choices, but which of us does not know some adult who hasn't made a poor choice of life partner in the past? It's part of life, it's why we have divorce. That adult is empowered to extract themselves from that poor choice. Those over 16 should actually be similarly empowered. The natural instinct of reasonable adults is to act protectively, but restricting risk and decision-making may actually increase risk, not diminish it. The overly cosseted child doesn't know how to make decisions and to protect themselves as they enter the adult world, which will be full of risk. So you say, what about the vulnerable? Well, if by vulnerable you mean those in need of care and support regardless of age, then in Wales the system is supposed to be seamless between children and adults. It should already be based on autonomy and what we call the people approach. There is no reason it shouldn't be the same in England. If by vulnerable you mean those aged 16 to 18 who do not have mental capacity, then the Mental Capacity Act 2005 is already there to protect them. That then leaves those who are vulnerable by reason of circumstance, those who have capacity, whose will is overborne, who are unduly influenced or subject to coercive and controlling behaviour. Where statute does not exist to protect that person, then the inherent jurisdiction of the High Court can and is used. It could be used to protect the 16-year-old with capacity, just as it was used in Southend and Myers to protect the capacitous 98-year-old. The age of majority does not need to be 18 to enable the law to protect those who need protection. Mr. Chair, we say that those are strong arguments for reducing the age of majority to 16, and we commend the motion to this House.
Thank you very much. Also for being within time, Ms. Henke. So we now move to the other side of the coin. The trouble with the judge is you hear a counsel such as Ms. Henke addressing you and you think, well, that sounds entirely plausible and there can't be any answer to it, but there always is. And we've got Deirdre Fottrell QC to address the other side of the motion. Deirdre practices at One Garden Court in London. She came to the bar after an academic career, but has continued to have an impressive academic career since then. For 3 years, until recently, she was co-chair of the Association of Lawyers for Children. She too is well placed to speak on this motion. So over to you, Deirdre. I don't know if you want to go across to the...
Thank you.
Yes, like me, you're better thinking on your feet.
I'm not sure I'd say I was thinking, you know, but anyway. Thank you very much, President and colleagues. I should start by saying when I was first contacted by Mrs. Justice Tice about speaking at this debate, and she said to me that the motion was should the age of majority be reduced to 16. And of course, my immediate response was, yes, what an excellent idea. And then she told me that she'd like me to argue against the motion. It's probably also right to say that having had the opportunity to have a brief discussion with Oscar Hatfull, who's going to follow me, I think, in terms of speaking for the motion, it may well be that the House might reach the position that not only should the age be reduced to 16, but perhaps it should be reduced to 13 or even lower, because Oscar has told me about his experiences over the last 4 years advocating to children for children's rights. So having said those introductory remarks, I should also say that Shabina and I, having had the opportunity to think perhaps more deeply about the motion than my initial response to be in favour of it, we hope to seek to persuade the House that the House should vote against the motion. And in looking to do so, I'm going to talk a little bit about international law and to talk a little bit about international standards and the importance of having universal standards in relation to things like the age of majority. And Shabina is going to talk in some detail about issues around child marriage. But in my 15 minutes, I'd like to pose a few questions for the House to consider, starting with thinking a little bit about why we might have an age of majority and what the purpose of having an age of majority is. I'd like to also then go on and think about where our concepts of childhood come from and why it is necessary to have beginnings and ends to these concepts. And then I'll talk a little bit about how the UN Convention on the Rights of the Child set the standard for childhood. And then I'll give a very extreme example to support my argument as to what happens when you lower the age and the consequences of it, looking particularly at the optional protocol on protection of children in armed conflict. One of the difficult things, I think, about a motion like this is the tendency is to view the question of whether the age of majority should be reduced to the age of 16 from the point of view of civil and political rights only. And of course, when one talks about civil and political rights, there is naturally a focus on children's autonomy, and there's naturally a focus on the importance of children's participatory rights. But it's really important when you talk about the age of majority to recognise that you're looking at the full canon of rights. And it's a much more complex picture when you move from looking at civil and political rights to also look at economic, social and cultural rights. It's also, we would say, reductive and potentially quite dangerous to focus in on adolescent autonomy, because arguments around adolescent autonomy are very much centred on participatory rights. But when you talk about children's rights from the perspective of social, economic and cultural rights, you also have to remember that what underpins the age of majority and what underpins protective legislation, particularly on an international level, are key pillars of the Convention around protection of children from harm, prevention of exposure of children to harmful practices, and those things travel together with participatory rights. So if we look at children's age of majority through the question of the full canon of rights, then a much broader set of issues come into play and a much more complicated and complex picture emerges. It's helpful perhaps to think a little bit about why we have an age of majority and why the age of majority has been set at where it has. In this jurisdiction, most of us will recall that concepts of childhood began in this jurisdiction during the Industrial Revolution. And the ethos or the driver for developing a concept of childhood was to protect children from working in the labour market, but also to ensure that children had an opportunity to have education. And the concept of childhood begins with the Education Acts in this jurisdiction in the 18th century, so that you have children entitled to free education, and that is set at a minimum age. That concept of childhood, I think it's important to recognise, is very much a Western concept, and it carries on into international legislation. And with it, of course, comes that focus on participatory rights. But when one stands back and recognises that the concept of childhood is different in other cultures and has different meanings in other societies, it's also important to recognise how the concept of childhood is strengthened and supported by the protective and preventive dynamic which emerges in the Children's Convention in the 1990s. It's helpful, I think, to think about the age of majority in international law and to look at where that emerges from. Ruth has given a wonderfully comprehensive and very appealing analysis of the variations under domestic law across a whole range of different situations in different contexts. I was particularly interested in the information that she gave that you could ride a low-powered motorcycle at, I think it was 11. Speaking for myself, many times 11, I can't ride a low-powered motorcycle, but I think it's interesting to look at the disparity across a whole range of issues. But the question that arises under international law, and the question which underpins the Children's Convention, is why do you need to have an age of majority under international law, and how did the age of majority emerge? Colleagues will probably know that Article 1 of the Children's Convention, because it's repeated, of course, in the Children Act, Article 1 of the Children's Convention sets the definition of a child as a child being a person under the age of 18 unless the age of majority is attained earlier. Now, there's a couple of points, I think, to note about that. First of all, it's the first time in a binding international treaty that the age of majority is set at 18. And it's enormously significant because the intention of the drafters of the convention was to raise the age of majority, not to lower it. Second point to note is that the convention itself allows for exceptions. And our submission, if you like, to the House is that that is dangerous and illustrates why the lowering of the age of consent, in fact, would abdicate the protective and preventive responsibilities that emerge, not just under the Convention, but under domestic law. If you look at the immediate aftermath of the Children's Convention, colleagues will know, of course, that the Children's Convention is the most widely ratified international human rights treaty, bar none. It has been ratified by 196 member states. Clear evidence from the Convention in the years after the Convention demonstrates that the inclusion of an age of majority had a very significant impact on the practice of member states. So in the years after the Convention was passed in 1989, over half of the countries who had signed up to the Convention raised the age of majority to 18. It's interesting also to note that 26 member states of the Convention raised the age beyond the age of 18, so between the age of 18 and 22. And what I thought was one of the most interesting statistics that I pulled out in my researches for this discussion was only 8 countries have set the age of majority as a matter of law between the ages of 16 and 18. And that in itself, I think, speaks to the universal acceptance of the necessity of having an age of majority and the benefit to children of doing so, deriving it or drawing from international law. Now, pausing there for a moment, I think it's important to recognise, and I do recognise, that Ruth has made some very powerful points about autonomy. And so it's helpful then to move on and consider when and how should the age of majority be relaxed. And it seems to us that the answer to that question lies within the Convention itself, and it lies also within the practices that have been imported from the Convention into domestic law. So the Convention has two core principles that are the drivers for participatory rights. One is the concept of evolving capacities, and the second is the concept of best interests. And if you embrace the concept of evolving capacities, you recognise that as children travel through childhood from 0 to 18, they will acquire greater participatory rights, and the protective rights may be, as it were, downgraded or recede. But the other key point, and you can't divorce these two core principles from each other, the other key point, of course, is that evolving capacities should not be applied without best interests, and that you should only look at lowering the age of consent if you can demonstrate not just that evolving capacities might justify it, but that it is in children's best interests to do so. I say that collectively as a group, but also in terms of individual children and in terms of the acquisition of participatory rights and the use of participatory rights. I think it's also right to recognise that there is real tension within international and domestic law as to how you reconcile these competing concepts under the Convention. And one of the things that we would suggest, and this I think may emerge a little more in Shabina's talk, one of the things that we would suggest is concepts of autonomy and protection are not in conflict with each other. Concepts of autonomy and protection are complementary to each other. But they do, in our submission, illustrate very much the benefit of having a solid legal age of majority, which is set at and tracks along with international definitions of childhood. Now, I said I was going to use a rather extreme example to illustrate the point that I wanted to make about what happens if you lower the age of majority, and it comes from the Children's Convention itself. One of the most controversial provisions of the Children's Convention was Article 38 of the Convention, which dealt with the issue of children's participation in armed conflict. And when the Convention was passed, it was potentially in conflict with the Geneva Convention number 4, which allowed for recruitment of children to the armed forces at the age of 15. And so states parties would not agree to the Children's Convention raising the age of majority in all circumstances. What happened subsequent to the Convention, and the way it impacts in this jurisdiction, is very telling and illustrates, I think, the wider point that we want to make. After the Children's Convention was passed, states agreed to an optional protocol, and the optional protocol does raise the age of recruitment of children to the armed forces to the age of majority, but also allows for an exception. Now, what happened is that those states which already did not accept a higher age didn't sign up to the optional protocol, or states like this state, unfortunately and regrettably, signed up to the optional protocol but with a derogation. Recently, in this jurisdiction, a report from the UN agency, the CRIN agency in Geneva, about the recruitment of children to the armed services in this jurisdiction. This is the only country in Europe which still recruits children to the armed services. Over 2,000 children a year between the ages of 16 and 17 are recruited into the army in this jurisdiction. And the CRIN report was heavily critical of the fact that the UN, over the 3 decades of the Convention, has repeatedly invited the UK to look again at its policy of recruitment of children to the armed forces and bring that in line with the age of majority. The reason I use that as an example is because it's all very well, I think, to cherry pick and say that children should be able to do this thing at that age and this thing at that age. But the only real solid protection from children being treated, if you like, as out with the protection of the Convention and not having the protective framework of the Convention, and I use the Convention coterminous with provisions of domestic law, is if you have a hard, fast, solid rule in relation to the age of majority. And there's too much of a grey area, as demonstrated by the optional protocol and the recruitment of children to armed forces between the ages of 16 and 18 to say that you can safely lower the age of majority to 16. Shabina is going to pick up right there and talk about forced marriage and child marriage. So I would commend to the House to say no to this motion. Thank you very much. I hope I'm in time.
You are. They're both, in fact, both a minute or two in time. Well, I did warn you it gets more difficult when the second QC gets up, and so it has proved to be. Well, now the debate will change because we've got contributions from a team of two, Imogen Tutt and Oscar Hatful from the Family Justice Young People's Board. Many of you will know, all of you will know, that the Family Justice Young People's Board, since it was started 10 years ago, has become an invaluable part of our thinking and development of our thinking in relation to family justice. They have an insight which is unique to them because of their experience of the system. And now it's a rare event that they don't contribute at, and their contributions are always extremely valuable. And so I've no doubt that tonight will be the same. So I don't know how you've arranged it between the two of you, but either way, you've got 15 minutes now to speak for the motion. Oscar first.
Hello, I'm Oscar. I'm 13 and I've been on the Family Justice Young People Board for 4 years. And I think that the age of majority should be reduced to 16 because there's a lack of consistency, you know. So people between the ages of 16 to 18 are left confused, and it can be problematic with some things being at one age and some being at another. And because there's no one day where they wake up and have all the information they need to become an adult and enter the real world. So with a lack of consistency like that, they're left with little experience and they don't know what, it can be hard what to do and what, because if they can't
Hiya, I'm Imogen. I've been a member of the FJYPB for 4 years and I'm 18. So for us, a lot of the issues with the current age of majority being 18 is that there are so many different inconsistencies between what you can do at 16 and what you can do at 18, and that this is confusing to young people because they don't know the differences. And it's also very difficult to make the argument that the age of majority should stay at 18 when 16-year-olds are probably exposed to just as much in the media or online in the more modern world, which is why now it could be a discussion for it to be reduced to 16. One of the points that we thought was interesting was that many young people from separated families grow up knowing that their court order will expire or end once they reach 16, and that these young people would not be given specific orders over the age of 16. So where does this leave children and young people now, and how are they to be safeguarded post-16 when their parents have parental responsibility for them? So if the age of majority was at 16, then the young person would be safeguarded by the maturity and not by their parental decision, or force. Another thing that we thought was really interesting is that you can fly a plane before you're allowed to drive a car, which seems a bit confusing and could be confusing for a 16-year-old with their age of majority being considered 18. And just more about how the votes are unequal in the UK. So if 16-year-olds can vote in Scotland and Wales, but in England 16-year-olds cannot have a vote, there is then a kind of a discrepancy between what young people know about politics and how much they engage, because if we were to have votes at 16 and consider it a full age of maturity at 16, then young people in England, Scotland and Wales would have the same rights, and these rights should be given with the responsibilities they have. And this links to how children and young people can have a full-time job at 16 in Wales and pay taxes and pay national insurance contributions, and they can join the army or they can get married with parental consent, but they're not allowed to vote. And this was another confusing point that we had about the current age of majority. Did you want to?
Do either of you want to add anything else?
No.
No? Great. Well, that's had the brevity for which we all yearn. And I look forward to you becoming barristers, but if you become barristers, you will then learn to take longer. But thank you very much indeed. Well, finally, we have the privilege of having Shabina Begum. Those of you who've read her CV will just see how impressive a person she is, both in terms of her practice as an international child lawyer in the field of children and women's rights, but also as an academic. And you will have spotted that she won the Woman of the Future Awards in 2020 in the business category, and she also featured in Management Today's 35 Women Under 35 last year list of Britain's brightest young business leaders. Here to save the opposition is Shabina. Over to you, Shabina. You're going to go across. Yeah.
Thank you very much for that introduction. Can I just say, I just remembered a meme that I saw about someone not wearing a face mask next to Sir David Attenborough, and I didn't want to be that person. That's why I've kept my mask on, because you are the treasure of the family law, so we must also protect you. Thank you very much. No. This is why I make the distinction. He's the treasure. I said nothing about age. Oh, Lord. But thank you very much. So, and I would also like to mention Imogen and Oscar. You're so inspiring, both of you. And Oscar, I just think you're so brave. So I'm here shaking because of you, actually. So on our side of the motion, I am going to, I suppose, focus on a very specific issue, as Deirdre had previously alluded to, which is child marriage. Now, for me, when we think about the age of majority, it is very important to focus on the impact and the consequences of such an act. And if we're going to do that, actually, how do we strike a balance of enabling and empowering our youth, and then also making sure that we're protecting and preventing any harm from coming to them? Now, it's a tough scale, but I've kind of like taken the approach of, okay, if we think about this whole discussion of children entering adulthood, how do we feel about essentially moving the starting line behind, right? So if we start at 16, how does that actually look? And in particular, how does it look for the more vulnerable communities? And I speak very much from a gender-based perspective, because that community cuts through every single intersect. Because we're not talking about colour, we're not talking about race, we're not talking about abilities, we're not talking about just socioeconomic background, but we're talking about everyone, potentially, that could be affected by this issue. Now, as has already been mentioned, the child marriage bill has recently passed its second reading, so we're hoping that this will become law very soon. But for the purpose of this discussion, actually the most important message that we feel like we finally have a victory on is raising the age of marriage and removing that exception that a 16 and 17-year-old can marry with parental consent or with judicial consent. But why is this such a significant move on part of the UK? Now, just to kind of go back to the whole global perspective, obviously we have signed up to the Children's Rights Convention, and so we pretty much agree that 18 should be the age of majority. We also then actually back the notion that child marriage is a human rights violation, and we very much stand in line with a lot of global communities when we say that. And the reason why child marriage in particular is so important is it does stand as goal number 5 as the UN Sustainable Development Goal to achieve gender equality. And this means to empower all women and girls. Now, very specifically, actually, the community that I am going to be speaking about are women and very, very specifically, are girls. And the reason I say that is because actually we need to think about sometimes the disproportionate impact that sometimes legislation has when we start to talk about gender. And just some research that I did, it was interesting to see how, for instance, when it came to the rape legislation, that was almost like the first feminist intervention that came about when it came to the law, and there was a lot of resistance then. Now we're kind of on the other end of the scale, where we have to be careful that any legislation or any move that we make now doesn't have a disproportionate impact the other way. And one of our arguments is actually, if you lower the age, that's one thing you will do. You will directly disempower a lot of girls. So what does that actually mean in practical terms, though? And the reason I say this, as someone who's done a lot of work on forced marriage, because child marriage still is yet to be legally recognised in the same way, what does this actually mean? And I'm just going to kind of go into this and break this down a little. So please do feel free to stop me if I go over for time. But the UK made a commitment actually in 2014 when we hosted the Girls' Summit to say we're signing up to this goal, so globally we're also going to eliminate child marriage and FGM. The following year, we criminalised FGM, so that's female genital mutilation. I'm sure most people know that, but I'll use that acronym. But then we waited about, 7 years now, to actually react to the child marriage part. Now, child marriage is also such an irreversible process, and the reason FGM was acted upon straight away because it had a direct health impact on a lot of girls, and so it could almost be seen. But child marriage actually has a wider impact, not just on the physical health, but the psychological, and then it has a knock-on effect on a girl's ability to access education, her economic empowerment. And for us, when we're talking about children and liberating children, we can't really talk about the wider participation if we take away their groundwork. And that's actually what we're at risk of doing if we do lower the age of majority to 16, that is. And the reason I say this, when we think about the consequences quite specifically of child marriage, and this has come through in a lot of global research, it does not only affect, as I was saying, a girl's ability to access, say, sometimes education, but sometimes this can put her in a position where she's going to fall pregnant far earlier than she should. This will then also subject her to a wider risk of being subjected to domestic violence. And these are real issues, core issues that we deal with in a lot of the cases that we deal with as family practitioners. In the UK, when we think the ideal scenario, I suppose when we think about that category of 16 to 17-year-olds, we want to think that actually they're thinking about, they've just finished maybe their GCSEs or the equivalent, and they're thinking about going on to do their A-levels or some kind of vocational course to then set them up for university. For some girls, that's not the reality. And actually, the thing that's protecting them the most right now is the system that we have in the UK. And for some communities that do subject their child to a forced marriage, it's the perception that they have to not only stay into school until the age of 16 and then go to college. That acts as a safety mechanism. And because they know that the child isn't 18, the child in effect isn't an adult, the parents have to still account to a system. And that becomes a protective factor, and that still actually behaves as a protective factor. Now, I just want to delve into the definition of a forced marriage quickly, because the UK defines a forced marriage as a marriage in which one or both spouses do not, or in the case of adults with some learning or physical disabilities or mental incapacity cannot, consent to the marriage, and violence or other forms of coercion are involved, and coercion may include emotional force, physical force, or the threat of physical and financial pressure. Just from reading that, I'd be curious to know how many people, even as adults, we just get that straight away, right? Most of us probably wouldn't, and it took me, I'd say, probably a good few years and a good few cases to actually understand what that definition means when we're trying to protect someone. You then give that to a child and say to them, or someone at the age of 16, you are now an adult, this is the definition of forced marriage, you figure out if you know what that actually means. And that's the fear and the risk that we'd be at if we lowered the age of majority, because we would then stick that responsibility on a child to protect themselves from something that's such a nuanced form of violence. And that's just one form of gender-based abuse. Now, as it stands as well, if we're going to look at a gap in the definition, if you like, forced marriage provisions do not protect, not only do they not protect, children at the age of 16 and 17 specifically, they're not mentioned, and a child does not automatically lack capacity for the purpose of the Mental Health Act. So what this means is almost like a gap in the definition, and sometimes we can actually lose children in that gap because children don't recognise that they're going to be subjected to a forced marriage. What that can look like for a lot of children, even in this country, is, oh, we're going to your cousin's house, or we're going to the mosque, we're going to the temple, there's going to be a ceremony there. It's not explained to them what's going to happen to them. They don't recognise those signs. And then sometimes there's that added risk of them being taken out of the jurisdiction for a cousin's wedding. That's what a lot of the language looks like, and that's what this child usually thinks that they're walking into, and sometimes even adults fall into that trap. What we would then do is, by reducing the age of majority, there's then no one else to actually support that category of 16 to 17-year-olds to actually recognise what's going to happen. And if they're not a part of, say, any kind of educational establishment, because it's definitely not going to be compulsory in any sense, then how do you protect that young person? Now, just to kind of throw a few stats out there, and this was from 2019, so before the pandemic, there were about 1,355 cases of forced marriage. And when those statistics were actually broken down, there were about 53 cases that had no overseas elements, which showed to us how actually forced marriage is definitely an issue within our jurisdiction. But then when those statistics were further broken down, it came to light that actually 199 of those cases involved victims below the age of 18. And then when you looked at the category of 16 to 17-year-olds that were then forced into a marriage in the UK, a majority of them were female. And then when you looked at generally forced marriage victims and child marriage victims, once again, predominantly females. And the other thing that made them even more vulnerable, and this is where another vulnerable category of people come through, is actually they were more at risk of a child or forced marriage if they had some kind of disability, or if they were if they didn't identify as heterosexual. Now, when we think about all of these difficult factors that we have to consider as adults, as a young person, and if we reduce this to 16, it will actually only heighten their responsibility to try and protect themselves. Now, some of the reasons that essentially child marriage has become an issue, just say if we focus on the Bangladeshi community, that's one of the communities that I work a lot with, some of the reasons that the parents will cite will be to protect the children from promiscuity, or to, if they're performing quite badly in school, they'll take them out of school. It's to encourage them to behave, or it's a form of punishment, or to hide their sexuality. Now, these are all very difficult issues that, as it stands, children can go to someone and explain that, actually, I'm at risk, or they'll know some kind of professional to go to. Once we take away that layer of protection, or that layer of support, essentially, it becomes far more difficult for a young person to protect themselves. And at no point should we ever put the onus on a young person to protect themselves. And this really came through in the FGM legislation in 2015, when we had to make a amendment to our criminal legislation to finally place the onus on the parents and created an offence of failing to protect your own child. And so are we saying that actually if we reduce this age, are we going to reduce it in terms of all of these child-led legislation? So actually leave girls at the age of 17 and 16 to figure out if they're going to be subjected to FGM, which is another tricky kind of harmful practice where they don't always recognise the nuances that they're going to be subjected to. Some of the things that I would say in terms of just negative impact as well in our submission. Now, when it came to forced marriage, actually one of the reasons why the immigration rules were changed, and I think you can only make a spouse visa if you're now 18, which is the age of majority, was because it was recognised that as a forced marriage survivor, you may come back and you may have to wait until you turn 18 to then make an application to bring that person back. So I suppose one of the questions would be, if we are thinking of reducing the age of majority to 16, do we then also change the immigration rules? And just to digress a little, just for a second, even when it comes to the youth justice system? Are we saying that actually suddenly we're going to try 17 and 16-year-olds under the adult system and not under the juvenile system? Are we then really going to give them a fair chance? So I suppose for me, I'm going to try and end on a key quote by, I think it was Juliet Allen, who's an American academic. She points out that perhaps the least acknowledged harm associated with forced marriage and child marriage, in my opinion, is the inherent deprivation of dignity, equality, and self-determination that renders forced marriage and child marriage an intrinsic human rights violation, regardless of whether the victim suffers psychological or physical harm. To put that into a bit more context, what that essentially means is if you subject a young girl at the age of 16 or 17 to a child marriage, it's one of the biggest decisions she never got to make in life. You can't then expect her to navigate the political system or actually be a fully functioning member of society when she never got to make that choice. And for me, that's why I would say, and in our submission, that we shouldn't reduce the age of majority to 16, because actually what we're going to do is we are going to leave a lot of children behind. And I would go with, just in terms of, if we're going to think of provisions as to how do you empower yet also protect, there are provisions, for instance, when it comes to driving. To get a full driver's license, you can do that at the age of 17. And that still enables and empowers the youth to go out and do something very practical. And child-led campaigns, in my opinion, have been the most effective when it comes to FGM and child marriage, because actually the most empowering thing a youth can do for another youth is empower each other. So it does give them a lot of knowledge, but that still isn't enough of a reason to then reduce the age of majority so that you then open up this category of other vulnerable communities who will never meet the mark, not at 16, not at 17. That's our argument. Thank you.
Can we thank all five of the speakers? Right. We now get to the stage when you can all join in and put questions to the speakers. It's all much more complicated than we thought when we walked into this room this evening, and I think, speaking for myself, I've learnt more than one thing tonight from each of the speakers. So we've got the opportunity now to tease out the issues. Jenny, have you got questions from online? So should we start with those while those of you in the room, you're not going to get off. If we take a couple from online, and then I'll see if there's some in the room.
Well, I should just say to start with that the chat is awash with congratulations for Imogen and Oscar for the heartfelt way that they put their arguments so persuasively. So well done to you. I think that gives a slight advantage that side. But we have got a few interesting questions. First question: How can the reduction of the age of majority to 16 provide clarity of rights and the necessary protection from harm?
Right. So, I don't know who wants to go first for that. Ruth, do you want to go first?
I'll happily go first, because part of our argument was based on uniformity. And actually, a number of laws are already centred around the age of 16, not the age of majority. And so you do have these anomalies. And you do have this grey area between 16 and 18 at the moment. And one of the examples that we discussed when we were preparing this is that if you're the entrepreneur at 16 and you earn a bit of cash and you're paying your tax, and then you get your driving licence and you're on the road at 17, you can walk into the fancy car showroom and you can have that car and you can drive it out. Nothing stopping you whatsoever, except if you can't pay for it, the person you've bought it from can't enforce it against you. Because if it is a really swanky car, if it's the Aston Martin or a Ferrari, is that necessary? And you can only enforce contracts against 18-year-olds, if it's under 18-year-olds, if it's necessary. And so you have these anomalies, and uniformity at 16 will bring tax, sex, the ability to actually have a roof over your head that's more than a licence, all under the same age.
Great. So if there's any car salesmen in the audience who've got their vote. Deirdre, do you want to respond, or Shabina? Which? You've got to be near a microphone, one or other. Good.
I suppose I think the point that emerges, actually, interestingly, on both sides of the debate, is that it's essentially a question of balance. And I suppose the issue that you're trying to tease out, and I think it is very complicated, and I don't think there's a straightforward solution to it, so it might be best just to have a draw. But I think the real difficulty is to think about what happens in areas for vulnerable groups and vulnerable children if you do lower the age of consent. There's a very compelling argument that it's very difficult to argue against, that if you honour participatory rights of children and young people, then you do that by lowering the age of consent, you do that by empowering people, by bringing people within the franchise, and all of those things which are really attractive. But you can't do that without thinking about the consequences in a protective capacity. It's really well illustrated, I think, by Shabina's points about leaving a category of 16 and 17-year-olds unprotected. And where I think you try to strike the balance is the balance must always come down, it seems to me, in favour of protection. There comes a point, of course, where as members of society, we are left to our own protection and our own devices. But the concept of childhood and the idea of minimum ages and ages of majority mean that you must define a category of persons who will come within the protective sphere, as it were, for a period of time. And the risk of lowering that so that you exclude individuals from that protective sphere at an enormous cost to them, I think has to be the thing that tips the balance. So that's where I would suggest, and I think Shabina has illustrated that exceptionally well. And that's not to say that the arguments about participatory rights are not compelling, because they are. They're very attractive, but they don't deal with that issue.
Thank you. Jenny, another one? Then we go
Yes, this is for the Family Justice Council, the Young People's Board. Are there any matters that you think should be left at 18?
That's an ideal one. Maybe stuff around credit cards, potentially. I don't know.
When we were talking about it, you made a point about what you can and can't do online with buying and the use of PayPal. Do you want to tell them about that?
The ages for PayPal are much higher than many of the websites that will let you pay with PayPal, and that was kind of a discrepancy. But
what's the age with PayPal?
18.
They got to be 18.
And when Oscar and I were discussing it, what were you were able to tell me what you wanted to do when you were regarded as an adult by society. So do you want to tell them?
Travel without a parent/legal guardian and drive a car.
Good, very good. That's very compelling. Good. Shall we see what's going on in the room? Yes, lady over there. There's a microphone coming, so you've got to pick.
Hello, good evening. Thank you very much. Catherine Braxey, freelance journalist and floating voter in a sense. But I wondered, those speaking in favour of the motion, so lowering the age to 16, are you concerned that it exposes more children to adult jails if they're convicted of criminal offences at a time when there's already lots of evidence showing that the brain isn't fully mature until people are in their 20s? So there's a bit like Shamina's point about the vulnerable groups, so offenders and prisoners. There would be many more people who would have to move from the children's. I know this is a family justice thing, but just to bring the criminal law into it, you would move more people into adult prisons.
Well, firstly, I think there are two issues. And the first issue has to be the age of criminal responsibility, because as a society, whilst we're worried about safeguarding those between 16 and 18, we place criminal responsibility on 10-year-olds. The next point is, actually, when there is serious crime committed, are they that protected if they're only 16 rather than 18? Because they will find themselves in an adult court if you are charged at 14 with murder, and there are a number of cases per year where you are. You will face trial in a Crown Court. There will be adjustments for you, and you may be on a wing for the under 25s, but you'll be in a prison. So actually, lowering the age doesn't affect that. This is a more fundamental issue, isn't it, about criminal responsibility for those that are under the age of majority. The issue is, where do you set majority, and where does society think you become an adult? And what we're saying is that's actually at 16, because we can do all the adult things, but what we can't have is the age of majority, because that's 18.
Shabina, Deirdre?
I suppose it might be an argument, might it not, for having a uniformity at the upper end, because it's very difficult, I think, to argue that an age of criminal responsibility of 10 is consistent with concepts of children's rights and protective approaches to children. And one of the themes that emerges time and again from the UNCRC committee with states parties is the age of criminal responsibility being too low, and everything that flows from that. So I think Ruth makes some really, really good points, but I wonder if there are not points about how you try to lift standards rather than lower them. And I think it's similar, I suppose, to the point that we were trying to make about the optional protocol on participation of children in armed conflict. That one of the ways that you try to advance children's rights is to set a standard that you then raise other areas to. So it should be the case that the age of criminal responsibility is much higher, and the protection offered to children consequent on that is mapped around the fact that the age of a child is below 18. But I don't, Shabina may want to add to that.
I mean, I think things are pretty much covered there, but the only thing I would add, and please correct me if I'm wrong, but I think even though you might be sentenced, it's me completely out my depth when it comes to crime, but my understanding was you're still given a lot of support in the background, for instance, as a youth, when you are going through a system, when you're not, obviously, 18 at the moment.
Systems
and
are
that's
different, but you are still on an indictment, as in some multi-hunt, as a co-defendant with adults sitting in a dock at 13 and 14, and it happens.
Jenny, do you want to do another one offline?
Okay. Sorry. Another online question. This is an interesting one. Maybe Denise Lester raises a point. If increasing the age to 18 for civil marriage, as per the bill, couldn't that lead to religious marriages only without the protection of civil legislation, for example, in financial remedy cases, or to nullify or void or voidable marriages? So if the age was increased to 18, what is going to happen about the religious marriages that accompany them? How are we going to protect those rights?
Right. Shabina.
I think, yes, when it comes to religious marriages, that's definitely been one of the difficult blind spots generally in a lot of the discussions when we've been discussing the actual child marriage bill. But I think the key thing, and I think you kind of the person went on to talk about financial remedies. Now in the UK, if you only have a religious ceremony, so let's say the nikah in the Islamic community, that's not legally recognised. And that's one of the things that we're trying to kind of push to make sure, because a lot of young people don't realise this, that they may be entering religious marriages, but they actually have no legal rights in that marriage, in effect, as a married person. And that's a separate issue that we are actually trying to deal with. But the purpose of obviously still raising the age of marriage to 18, and this is one of the things that came up in terms of immigration laws, because sometimes the parents will take them to another country for the purpose of a religious marriage. And once that happens, and even if they're under 18, even though they may not be legally recognised here as a particular spouse, they will wait until they're 18 because they're still emotionally and religiously in their head married to that particular individual, and that subjects them to a lot of abuse, that waiting period, and that's what we're trying to remove. Like, that onus should never be on that young person. And so once you reduce the age of majority, you're actually exposing them to more risk, and because then actually they could literally be taken to another country at the age of 16, get married, make an immigration application for that person who usually is quite abusive, and then that opens them up to not just physical abuse, rape, being a mother at a very young age.
Ruth, Deirdre, Imogen, Oscar?
When we were talking about it, one of the things we were discussing was about how you should empower and educate, and we see the way to being rights-based and recognising independence is making sure that that person who is subjected in Shabina's examples actually has a proper voice, and it's not just about participation and being listened to, it's about being able to do something, and that means educating them and educating society to say it's not acceptable, because it's not acceptable. It's just a question about how you stop it.
Yeah. Back to people in the room. Anyone? Now, don't speak until you get the microphone ready for the benefit of the people online. Jerry, I know your voice will carry in the room.
So Jerry Bull from Atkins Soap, I'm solicitor. Against the balance, I'd worry in terms of we reduce the age majority to 16. We have young refugees come to this country who we are meant to treat differently between 16 and 18, whether we always do and whether we have the tests. I worry about if we reduce the age majority in this country, how that's going to affect our ability to deal with refugees between 16 and 18, and indeed how far that would put us out of kilter with other jurisdictions, returning children at that age, and how would that work in terms of how we could deal with that. I just don't know.
Thank you. Go first on that. Ruth?
I think it's me first again, isn't it? And I think you focus on one of the very interesting exceptions, and perhaps that's how we need to deal with it. You reduce the age of majority, but the immigration rules have a different age. Why does it always have to be the latter age? It doesn't. It is a legal construct. There is no magic in the figure. And that's why we can all have sex at 16. We can all go and buy that, not buy a house, but we can have a license. We can set at home with whom we like. We're an adult. If you asked a person in the street what an adult is, they'd say that's the person that can live on their own, can choose to be with whom they want to be, and can work, and can pay taxes. And so why don't you have that as the norm, and then protect those that are outside the norm, as the exception rather than the rule?
Deirdre, Shabina, do you want to contribute or not? You don't have to, or you all don't have to say something with everything.
Oh, I think the only thing I would say to that is, I think the difficulty, how do I put this? One of the things that we don't want to do, especially when it comes to refugee communities, is treat them like second-class citizens. And actually sometimes what we do is if they're outside the scope of our age, and this happens when it comes to child marriage, we can't say, actually, another girl who's entered the jurisdiction, we're not going to protect you under the same laws because you've arrived from another country, if we're at the same time trying to say, we're going to let you integrate into our society. And that would be my only kind of, and I've seen it play out in practical terms where actually a lot of young women think they're going to be protected in the UK, and they think they're going to be protected by our laws because we have quote-unquote better laws or more stringent laws than they do, only for them to realise that they actually currently are kind of in an exception. So that would only be my concern as to actually why we should have a uniform age of majority even in those situations.
Thank you. Jenny? Or Melanie?
I'm actually in the room, not online, but I'm Melanie Carew from Cafcas, and also a floating voter so far. But I just wanted to ask about there's a large number of cases of young people of 16 and 17 who go before the court with applications under the inherent jurisdiction for deprivation of liberty orders, and it seems likely that if the age of majority was reduced to 16, those cases wouldn't come before the family division and they wouldn't actually go anywhere. And who would be responsible for protecting those young people who have capacity, are making perhaps poor decisions and are vulnerable in many ways? They're not looked after by the mental health system, but currently the local authority have some kind of responsibility for caring for them. And I do worry about that group of people, and I wonder if the panel had thought about that as a possible consequence if the age of majority is reduced.
Right. Have you thought about it? No one's mentioned it.
I haven't thought about it, that's the answer, I think. I think what I think emerges from the questions and the comments is that the cluster of individuals who are affected by reducing, or adversely affected by reducing the age of majority, are a cluster of individuals comprised of the most vulnerable children at the age of 16 and 17. And that really comes back to this issue, doesn't it, as to what's the purpose of having an age of majority. I think the other point, and it sort of relates to what Melanie is saying, and it sort of relates to what Jerry said, but what I think is illustrated from practice is it's hard enough to keep a state, including a wealthy state like this state, to the obligations that arise from having an international age of majority at 18. There's a real practice of derogating around areas that are involving expenditure. And many of the areas around civil and political rights don't involve expenditure. They're about issues to do with autonomy, and those things don't come at a price. But when you start to talk about child refugees, or you start to talk about children deprived of their liberty under the inherent jurisdiction, those things, to improve the quality of those children's lives, does require expenditure. And if you declassify them as children, I think Melanie's point is a really powerful one, that they just float off into an unprotected category of persons, and the justification for that is really quite weak, it seems to me.
My fellows see it slightly differently because I come from a jurisdiction where we have the people approach, which is a person in need, whether they're 16, 17, 18 or 19, they're a person in need. So when you're talking about meeting needs, you shouldn't be looking at age, you should be concentrating on the need and providing the facilities for them. That's the first point. The second point is inherent jurisdiction. We think of it in terms of 18 and under, I think principally because of the Section 100 criteria that we have to meet. But actually the inherent jurisdiction under the Senior Court Act is used for people above that. The person I mentioned in the Myers case that needed the protection of the courts was 98, but they had the protection of the court when it was needed. So there are systems there that can be used. You do not have to keep using that which you use day in, day out, because it's habitual. You need to start thinking of it again and thinking, actually, if at 16 in reality you are treated on the street as an adult, shouldn't our laws reflect what is happening on the street? And there will be vulnerable people who are over 16, and we have systems to deal with that. And perhaps we have a better focus on it because we're recognising it rather than fudging the issues.
On this point, a real worry is that some of the young people who come before the High Court for authorisation of deprivation of liberty have been involved in county lines, and they're being protected by the local authority. Hitherto, I think 10 years ago, they would have been in the criminal justice system, but they're rightly seen as victims. Now, if the majority is reduced, then it may be that they would just go back into the criminal justice system. But I don't know. But I'm still neutral on that. Now, that wasn't truly from the online contribution. So, Jenny, have you got a...
Okay, possibly to start with Imogen and Oscar again. If the age were lowered to 16, what support do you think would be needed, possibly in relation to some of the more vulnerable areas? What do you think, what extra support do you think would need to be put in place?
I think a lot of the stuff that we spoke about before was about education in school before. So this could be through like citizenship lessons and just having more conversations about rights and responsibilities and different protections, and in example for vulnerable groups, institutions that can help them. So I think, our main argument back to that would be about education and making sure that children are well informed at a younger age, and so if it was to be lowered to 16, by 16 they would be fully aware of the different rights and responsibilities.
Good answer. Anyone else? No? No, that's floored them.
the chat about the issue of education and the importance of getting that piece of the jigsaw right, and it sort of sounds as if it really needs to be the precursor in order to be able to enjoy the benefits rather than running the risks.
Yeah.
That was just a comment, not a question.
Right. Back to the room. Anyone? Yeah. Yes. Lord Justice Baker.
One halfway house might be to lower the voting age to 16. That would enable young people of 16 and 17 to have a say in how laws should be changed. After all, it could be said that we don't do a great job in protecting them at the moment, and it may well be that if we gave them a voice, political voice, to say how laws should be changed, rules should be changed, we might get a better and fairer system. Would that be a solution which might attract everybody, or not? I see Deirdre's nodding to that.
Yes, that sounds like a good solution.
So you'd still win the debate, but it would be
That's why it's a good solution.
in favour of your Ruth.
Well, practising in Wales where they do have the vote, it's part of the solution. But it isn't the complete solution, because you then have an enfranchised 16-year-old who has the ability to live a life of an adult and is still treated by the courts as a child. And the other point is that when you start to look at it and you've given them the vote, we talk about child's rights and the vulnerable because, of course, they must be the focus of our attention. But in proposing the motion and doing the researches, what you're actually looking at is an awful lot of old law about contract and civil responsibilities, and actually not about children's rights at all. And if you're going to be serious about children's rights, then you've got to be serious about autonomy. And autonomy isn't just giving them the vote in local elections. It's about hearing them, listening to them, and then acting on it. And that means reducing the age of majority.
I've just thought that we haven't had a discussion about whether Oscar gets a vote in the debate. I'm sure he does. Anyone? Jenny, from online.
There's no more additional, there's comments, but not so many questions left online.
Right,
I have a small question. Can I ask a question? I'm just wondering why 16. I'm just wondering why we've got 16 as the option as opposed to 18, and what people think about whether or not. Why have we arbitrarily picked 16 then?
Well, part of the reason the Welsh chose 16 for the voting age was the old saying from my O-level history, because I'm that old, no taxation without representation. You tax a 16-year-old, so why shouldn't they have representation? And then you look at the ages, and actually you have the 1969 Act giving you the age of majority of 18, and then you've chipped away at it and chipped away at it and chipped away at it. So again, going back to O-levels, this time O-level maths, there used to be something called the mean, medium and the mode, the forms of average. I can see people nodding in the room that remember that. If you look at what the age that falls in the middle of the continuum, it's 16. And that's why 16.
Why 16? Of course, you two didn't choose 16, did you? So it's also, politics is the art of the possible, so 16 is a good starting point anyway. Jenny, do you want to read out some comments, and then please anyone in the room do contribute? Yeah.
There's a question here about does anybody know the statistics for young people living independently at 16 and 17? I wasn't sure if any of the panel actually knew the answer to what level of young people there are living independently at that age.
No. Lucy, have you got a question? You've got to wait for the microphone because the people online can't hear you.
I was just going to ask Oscar and Imogen if they advocate the age of majority to be reduced to 16 when they think of their friends and whether they think actually it would be a good thing for all of their friends, or whether it would just be for people as mature as they are.
I think it should be for everybody of an age. I think when you're 16 and you've completed all your years of mandatory school, regardless of competence, you should still be allowed to have a say and to have consent to basic things.
And is there, can I have a supplementary? Is there, sorry, is there anything that you think shouldn't be at 16, that you think perhaps should stay at 18, or do you think it should be absolutely everything?
I think it should be a plain slate. I think everything should be at 16.
And is that because you think it's clearer?
It's clearer and it's more concise and it's simpler.
Imogen, same for you?
Yeah, I would say the same things as well. I think it's a lot about when you finish schooling, compulsory schooling, to keep the age at 16. Yeah.
Anyone else want to come in? No? No. That was 3 questions. Anyone else in the room? Yes, the gentleman at the front. Thank you.
Fundamentally, do we believe that children are now, at the age of 16, are more informed than in previous generations? Or the counter-argument that they're still not more informed?
Have the goalpost moved?
Well, they're certainly better informed than I was at 16, but that may be because I was born before the age of the internet.
I think a lot of it as well is about what children are exposed to, and young people are exposed to now in a more modern world with the internet and with news, how easy it is to be just informed on what's going on in the world, and the use of technology. So yes.
I feel too old really to answer that question. I don't know. Feel comfortable saying whether children are better informed. I suppose one of the things to bear in mind is the deluge of information that is available to people doesn't necessarily mean that they're better informed. I don't know that any of us are better informed. But I'm not sure also that I think that that's a factor that needs to be taken into account. I suppose one of the things about information is it assists people to claim their autonomy, and there's an extent to which it empowers young people to claim their autonomy. But when you start to look, and this obviously is a thread that runs through our discussion, but when you start to look at some of the more complex areas like reproductive health and children's sexual identity and adolescent sexual identity and sexuality, some of those issues are made more complicated by the way in which information is received and access to information and availability of information via digital means. So I think it's quite a complicated thing to understand and evaluate. But I'm too old and far away from young people to really be able to answer that properly, so I defer to the younger members of the panel.
Anyone else? No. No. Anyone in the room? Barbara.
Barbara Connolly. Just following on from that, from the last question, if the question that's been asked is, are 16-year-olds better informed than they were in the past, one might reverse that. If the rationale behind having an age of majority is the state's duty to protect children, are we really saying that 16-year-olds are in less need of that 18-year-olds or 16-year-olds are in less need of protection than they were before?
I'll start and then I shall defer to my young colleagues. But I don't think, first of all, that the age of majority is necessarily set by the need to protect. When you look at it, it's actually about the protecting of society from them, and that's historically where it's come from. And you look astonished, but that's civil. It's about the ability to void contracts.
That might also be to protect the child from being from having
It could be, but it's not simply about protection. It's about empowerment from our perspective. And that's the reason why we propose the motion, because actually a paternalistic society is a historical society, and we should now be living in a society of rights. And if we really do respect rights, we should be respecting the autonomy of those that are able to express their rights.
Deirdre, Shabina, Imogen, Oscar?
I think there's some interesting discussions about adolescent autonomy at international level. And about 3 or 4 years ago, the UN committee issued its first general comment on adolescent autonomy. And one of the things I think it confronted in the general comment was the observations that Ruth had made, this idea of focusing on the deviance of adolescence, or the dangerousness of adolescence. And the general comment really shifted the committee's attention to the importance of participatory rights. But I don't think you can say that the claiming of participatory rights or the claiming of autonomy can be entirely devoid of any consideration of protection. Because insofar as autonomy for anyone brings with it responsibility, it also exposes individuals to risk. And that's why you have a spectrum. And that's why you have the concept of evolving capacities, that you don't expect a person to bear a burden, whatever that might be, a civil burden or a political burden or an economic or social burden, at a point when they don't have the capacity to do that. And I don't mean capacity as in mental capacity. I mean capacity in the broadest sense. And that's my understanding of where the committee landed in its general comments. So I think there's a real recognition of how unattractive it is to characterise adolescence as deviant or dangerous or threatening or whatever it is. And I think that's Ruth's point. I think the debate is much more sophisticated. But those two competing tensions, I don't think you can ignore them. It's too reductive to simply say autonomy is there and we should be able to claim it.
Thank you. Anyone else in the room? Anyone else online? Any comments? Happening. We've been realising we haven't actually organised how to vote online. And so a number of us have been shuffling around the room inconspicuously. I think we can have a form that can be put online by the Amplitude team. And will it be for, against and abstain? Yes. And how long will it take you to get that? We can launch that whenever you're ready. So have we, Jenny, got one more?
Just one more question. I think this is quite a useful one to end on. Moving from a child to an adult involves a huge transition and a development of maturity. Isn't it helpful to have a period of time where a young person has some, but not the entire gambit of responsibilities, so a sort of halfway house?
Right. A launch pad. Is it a useful thing to have? I can almost predict what the answers are going to be. Oscar.
I don't think it's useful. It would, if anything, it would feel more like you're trapped, as in you can do some things, but you can't with others. So it wouldn't be helpful, really. It'd just be it wouldn't feel like a starting ground. If anything, it'd feel like you're in quicksand. You're trying to get out, but you can't for another 2 years. It's just impractical.
I can't better that.
No?
To that response, it's not a response per se, but the only thing I would actually say in response to that question is just to kind of draw an example from a jurisdiction where they almost do have this system. So in the US, where actually you can become emancipated as a teenager, and this is kind of played out in different ways, and essentially you become an adult as soon as you are emancipated, so your parents have no rights and you can access rights as an adult, so to speak. And what that has actually resulted in is a lot of teenagers overnight have become homeless, and the state has no responsibility towards them. And what it has created is another category of extremely vulnerable young adolescents that actually need support, but they're considered adults in the system, but haven't actually been given a fair chance to be so. And I say this, it's that concept of actually that reprieve period. So actually, while children in the US are very much respected, so young people are respected at that stage to be quite empowered. And in the US, some of the conversations that they have about identity and autonomy and independence, I feel like, are far more advanced in the UK. But in reality, they have also highlighted some of the risks, and it is actually, have they protected these young people or just launched them into unfortunate situations like homelessness, which is a huge issue.
All right, that brings things to a close. I haven't fully resolved the question, what am I going to do when I grow up? So it is a moving, moving thing, doesn't never quite ends. So looking at the Amplitude team, presumably it will happen real time. If I ask the questions in the room, then people can fill in their forms. We'll obviously do the show of hands in series, but people watching can presumably fill in their forms at any time now. And how long will you need to give them? There's no reason why we shouldn't give them a very short time to do it. So the questions are on the form. Does it say yes or for or no and against?
So they have, I am in favour, I am not in favour, and abstain.
That's great. Okay. So the motion is, should the age of majority be reduced to 16? I am in favour, vote for that. I am against, vote for that. I abstain, vote for that. And we'll do that in the room now. We've got tellers dotted around. I can tell you there's only about 15 of us in the room. No. And the panellists are allowed to vote as well, including Oscar. So should the age of majority be reduced to 16? In favour? Kim, are you counting? Or Jenny's counting? That's fine. And anyone? Jenny, are you in favour? Yeah, good. Thank you. Put your hands down. Should the age of majority be reduced to 16? Against? Abstain. Just purely. that laugh was because, oh, I'm on camera. I've got my hand up. There we are. Good. So, can we add the in-room totals to the online ones? But if there's a difference between online and in the room, it'd be quite interesting to see. Quite exciting. The only time I come to this building is to vote. There's a polling booth, and I don't live far away, and it's really exciting. I come early in the morning because it's on the way to work, and because it's in Westminster, there's always a little bevy of cameramen and women outside. So I dawdled for a long, long time, but they didn't show any interest in me at all. Right. Yeah. Yes. Right, here we are. God. Right. So 5 people abstained. In favour of the motion, so that the age should be reduced, 23. Against the motion, that it should not be reduced, therefore, 43. So it's more clear than I would have thought. And there we are. Well, I thought, whatever the outcome of the vote, I thought it was a really interesting debate because of the quality of the detail, the work that you'd all put in to researching the points and the history and the little teasing out of the issues betrayed the not only the work you've put in, but your experience, but the experience of Oscar and Imogen, who come actually knowing what this is all about in a way that we don't or have forgotten, was extremely valuable and added very much to the overall quality. So can I thank everybody to applaud them now, whether you're at home or in your office, online or here. I just need to thank Kim and Daphne from the Family Justice Council. These events just don't happen, and to organise this in the middle of the moving field of the restrictions has been very tricky. They found, I think, a really good venue here. I think those of you who aren't in the room, this is a good place to come, and I'm really, really grateful to Kim and Daphne for what they've done. So thank you. And my phone tells me that the Prime Minister has announced that people should now be working from home from I don't know what day coming soon. So well done for picking the last date you could pick as it happened. Has it? You can still go out? Oh, well, there we are. The night is young. So safe home to everyone and happy Christmas. Thank you.